Hi, everyone. This is Curt and welcome to another edition of Fire Law Roundup for March 28th, 2022. And we've got my friend Bill Macarone here. Bill's going to talk about an FLSA case to kind of get us started, and we'll get back to the normal routine right after that. So, Bill, welcome first of all. And
Thank you.
What do you
for having me.
Yeah, well, we'll love to have you. What do you got for us?
I got an interesting case last week, settlement last week out of Kansas City, Missouri. So we have to specify there, Kansas City, Missouri. The caption of the case, it's Adams versus Kansas City. It's a regular rate lawsuit that was filed in 2019, and regular rate lawsuits, as we know, are almost commonplace today, especially in the fire service when it comes to firefighters being paid a salary, paid a salary versus hourly, and all the other issues that come from that. But specifically, what really was interesting about this case, I found interesting, is that the case revolved around something that the contract called specialty pay. And what specialty pay was there were wage augments that were given to firefighters that possessed certain certifications or had certain qualifications. And they ranged anywhere between 3 and 10% of the firefighters' wages. So it's a significant amount. It added up to a decent amount of money at the end of the week, end of the year, et cetera. And just give you some examples. There was if you're on the hazmat team, you got a 3% bump. If you're a hazmat tech, you got a 5% bump. Things along those lines that folks got. And the issue that Kansas City ran into, at least in the lawsuit and then subsequently settled, was that firefighters in Kansas City work an average of 49.5 hours a week. And the city was including those wage augments in the firefighters' wages for those 49.5 hours or 99 hours every 2 weeks with their biweekly payroll. But then when the firefighters worked additional shifts, they were paying the firefighters at least is the allegations of the firefighters, they were paying them at their base hourly rates up until that 212 number every 28 days, which is permissible under the FLSA. That would be okay. But then once the firefighters went over 212 in the 28 days, that's where your regular rate calculation really needs to kick in. And according to the firefighters' complaint, the city wasn't doing that. The city was not including these augments within the overtime calculations of when they work more than 212 hours every 28 days. So the interesting thing, and at the end of the day, the lawsuit went on for a couple of years. The city filed a few motions, and there were a couple of challenges to the lawsuit. At the end, last week, they settled about $2 million, just over $2 million. It was 1.76 to the firefighters. About
how much do their attorneys get?
300,000, which actually was not outrageous. It was not not outrageous, but it was not a 17%, because it broke that down, which is not out of the realm. In fact, that's the lower, in my opinion, in my experience, that's the lower end as far as your percentages are concerned very often, especially after 3 years of contentious litigation. And it obviously, like all these settlements, the city, denies wrongdoing, and the plaintiffs also continue to allege that they were correct. But the issue at hand, and what I think makes this really relevant, is the city's main argument was that, or one of the key arguments at least, was that the CBA specifically stated that specialty pay, and the quote was not regarded as wages. And the city kind of hung their hat on that rationale to say, listen, this specialty pay is not regarded as wages. And at the end of the day, the court said, no, the FLSA requires it be included, and the regular rate calculation has to have all remunerations, et cetera.
I was going to say, you could say it's not wages, but it still can be remuneration.
If it's guaranteed, right? Am I correct? It has to be guaranteed.
Yeah, discretionary versus non-discretionary is
the FLSA,
a big aspect of
but
that.
The FLSA says if it's remuneration, you have to include it in the regular rate. So you can call it wages, you can call it whatever you want, but if it constitutes remuneration, it has to go into the regular rate, unless it fits an exception. Go ahead.
Let me ask this though, as just a spin for people. So if it's not my understanding is, if it's not guaranteed at the time payroll is made, that's my question here, the spin, and it doesn't have to be included in the overtime. So one of the things I see a lot of fire departments saying is, if you are still employed by December 31st, then we will give you, right, then you earn the annual stipend for being an EMT. But if you're not so employed, or you're no EMT,
I'm going to draw it.
Would that matter here?
Yeah. Well, I'm going to draw a laser line distinction between guaranteed and discretionary and non-discretionary, because the FLSA uses discretionary versus non-discretionary. And if something is non-discretionary, meaning I think it's fair to say guaranteed, right? I mean, that's kind of, then it has to be included in the regular rate. If something is is discretionary. And what I mean by discretionary is the employer holds kind of control right up to the last minute of whether or not they're going to give this bonus out, going to give this extra money or extra remuneration. Then you could exclude it as a discretionary bonus.
Well, if it's a bonus, but if it's discretionary, it's not really a bonus. It's a discretionary payment that's contingent upon you working 12 months in a position or 6 months. Then it's not really discretionary. It's just that the question is, are you going to actually, stay with that certification for a full year? But here's the point: the FLSA says once someone qualifies for that, you have a reasonable period, which is really one pay period, to make up whatever the difference is.
Yes.
Right.
So we would go to the your language, right? Once somebody qualifies for it, what is qualifying? Is qualifying you only earn it under my hypothetical if you're still employed on the last day, or it didn't matter?
I think we gotta kind of draw a distinction between what Bill brought up, which is bonus, and I think a lot of times bonuses comes into this. And then people try to apply bonus to something like a paramedic stipend or a hazmat stipend or something like that. Paramedic stipend, hazmat stipend, that's not a bonus. You can call it a bonus, right? And Brian's famous thing, right? You can call a cat a dog all you want, right? It still is a cat. So you can call it a bonus, but if you give somebody an extra $50 a week or $5,000 a year, however you're going to parse it out, and that's part of your agreement with your employee, that's not discretionary. It's not, you may hold it until the end of the year, but it's not discretionary. But like Brad, I see you smiling. In your office, I'm sure. In your office, I'm sure that you give out an annual bonus. Okay,
and I'm not the government and I don't have a constitutional prohibition against.
And here we go. And that's the point. And that is the point. That is exactly the point. But I'm going to tell you, and that was what Billy and I first. I think we did an early class. Bill, was it North Carolina? And we said we got into this part of it, and we said, well, no government gives out bonuses, right? And then we give out a turkey, or we give out and
Christmas bonus.
Christmas. There are places where I know.
It was
I haven't read
for
every
us.
state's constitution, but I can tell you, the federal government and New York State, at least, absolutely unconstitutional to call it a bonus. So feel free to call it bonus all you want. You've got other issues.
You can call a cat a dog, but.
Well, what I think it just kind of draw quickly back to the Kansas City case. What was so relevant to me was folks that read my blog regularly, they're going to remember a case last year. It was just May of 21 that I blogged on another Kansas City, Missouri case, where there was a question about how the regular rate was calculated for not firefighters, but the fire department medics, non-firefighter medics, so your single role medics. And in that instance, the way that the city reached the calculation of their regular rate was a little bit convoluted. It was a little bit, we discussed it, Curt, in the advanced regular rate class, because it's really in depth, but it was a complicated way of determining their regular rate of pay, basically for purposes of overtime in that case. And the Eighth Circuit said, listen, you reached this agreement through collective bargaining, and we respect the bargaining process. So it's kind of ironic that and I get both, there are distinctions between the both, and too much, we can't go down that road here, but there are definitely distinctions between the both, but it goes to show you just how complex this can be. And that the Eighth Circuit, the district court, the same district court, and the Eighth Circuit in that instance just a year ago said, listen, this agreement was reached through collective bargaining. We're not going to really do, an agreement between the parties. And now here we are a year later, and the city's defense is it's not the same contract, but very similar contract, saying, look, remember us from last year. And in this instance, they said, no, that, it doesn't fly. So it's interesting. And I found it to be very interesting.
Well, Bill, thanks. And I do want to put in a plug. And Bill, you're going to hang in with us for the rest of the half hour, 45 minutes or so. But I want to put in a plug for Bill's class next week on advanced. It's an advanced FLSA webinar Wednesday, April 6th on 21st century off the clock work, like what happens when a firefighter responds or reads an email, responds to an email, work-related email from a supervisor, the compensability, completing incident reports while off duty, even preparing, policies, procedures, or RFPs, RFQs, and different things. Just that off the clock aspect. So good. It's an advanced level class. So, but more information that you go to Fire Law blog, click on the courses tab, and you get the information on it. So,
thank you.
All right, Counselor Pinsky, where are we?
Tell you, if there is anybody not listening to these video live sessions, they are missing out, and I'm going to call it on free insurance, because you get to look at what other people are accused of doing or have been found to have been doing, or just what they're getting sued for. You get a chance to take some proactive steps in this. And I mean, if you are not watching Curt and I, and hey, Bill when he's here, if you are not watching the show, you are giving up the right to protect yourself. In any event, so today's examples, I'm so excited about when I read these. They're just, some of them are mind blowing about like, how much can you protect yourself against? But let's start off with the first one in South Carolina. First of all, the fact what's that?
Who would have thunk it? Snow in South Carolina.
Yeah, right. The fact that anyone's sledding in South Carolina is automatic reason there should be a lawsuit against somebody. So why not? Right. But here, and look, these are the allegations. I'm just reading them. But basically, there's a big snowstorm in South Carolina. The roads, they admit, the plaintiff, the person suing admits, the roads are shut down. So enter two parties. We've got this guy who's ultimately injured, who's sledding down a street, not a hill. He's sledding down a public road, right? And a sled is probably not a qualified motor vehicle to be going down a road. But he says, hey, the road was shut down. Enter the fire department, who's on a UTV doing something, right? Driving around on these closed down roads. The UTV may or may not be, I don't know, a qualified motor vehicle, but they're not doing anything on an emergency, or maybe they are, right? The claim is they're not, but maybe they're driving around looking for things. Who knows? In any event, the UTV, which is allegedly traveling at a high rate of speed or higher than safe, allegedly, it makes contact with the guy coming down the hill on a sled and ultimately results in the loss of the guy's leg. So they sue, and part of this is laughable, and I don't mean to be laughing at any of it, but part of it's laughable only because they're suing the fire department for negligent hiring, negligent training, and negligent supervision. And I'm trying to think, as an attorney who does a lot of hiring, with clients. So firefighter so-and-so, if it was snowing in South Carolina, what would the appropriate rate of speed be on your UTV in order to avoid people coming down the hill on a sled on an open public road? I mean, I hate the fact that this happened, right? Obviously commiserating that it happened to everybody involved. I mean, can you imagine not only being the person who got hit, but the person who runs them over, but then to get sued? So here's one of those good questions of, was there a breach of duty? Yeah, there's your basic negligence lawsuit. A guy on a UTV obviously has to be, careful. And was he driving appropriately? To me, I haven't seen the response, the answer yet, but I'm saying assumption of risk. You sled down an open public road. You pretty much deserve whatever happens to you. And we understand it was all good times. You assumed nobody was coming, but you were wrong. And you slid down an open public road. I say, that's an assumption of risk and should bar all liability. I don't know anything about South Carolina's comparative contingent liability, but that's just one of those things like, my God, what can the fire department do to avoid issues? So I don't know if you have anything more on it, but I
thought it was really the shotgun approach that we talk about here, going after the department on negligent hiring. And, making an allegation is one thing, but they're going to have to prove, in order to get by the motion in limine on that particular issue, how do you connect the hiring to the accident? Like, even if you were totally negligent in hiring this person, how do you connect that to cause it, other than the but for? You have the but for, you can't get around that. The person's mother would be a but for cause, but how do you have the proximate cause? So that's more for the legal eagles. I don't want to bore everybody else
Isn't
with
that
it.
us?
Yeah. Well, it is. It is. And I know we've got some firefighter attorneys out there, that listen to, but for the firefighters, it's just another one of those,
Right.
Here we
But
go.
I move to dismiss again. I'd say assumption of risk. You sledding down an open public road on a non-approved motor vehicle, you pretty much get what comes to you.
All right.
And I'm not trying to be, mean about it. Okay. The next one is a great lesson. I have this happen to my clients probably once a year. But this is so dramatic. Here, a Alabama medic is charged with stealing 42 vials of fentanyl. 42. Now, first of all, the fact that a fire department keeps 42 vials of fentanyl, what the heck is going on in their community, right? That they need so much fentanyl. And I don't remember if anyone knows what the expiration dates of fentanyl are, but that seems like a high volume of fentanyl.
Yeah, and one thing, I'm not sure it was stolen all at once. And that's another thing. It has to do with our inventory control, because, if you take one here, over the course of several months, point being, we've got to be paying attention to the inventories, because if we're not, then you're going to find yourself, if you do your inventory once every 6 months, then you're like, oh crap, now what? As opposed to doing it on a more regular basis.
And let's stay on that, because that's where I was going. So it's not just inventory, because I've said this before. We've had this case a number of times. The problem with inventory is there's two guilty and there's two accusing people, the same people, right? When I do inventory and I discover it's missing, all of a sudden I'm like, it was the last guy. The last guy is saying it was there when I did it. It's you doing the inventory now. You never know who did it. So the only thing that protects people, Curt, you said this on this radio or the video show a number of times, video. You've got to video all of your narcotics. Obviously, you're going to have the two-factor, finger scan or whatever. It doesn't matter, all right? Because you can't tell who took what. Video is the only thing that matters. But one more thing, every time that's opened, and I mean this, and people are like, you can't require that. I said, oh, you better believe it. Every time that safe is opened, that video should be reviewed. So look, that's every time you've restocked, right? That's not every time you're just doing inventory. You might do once a week inventory, right, in the safe in what we call the sub stock. But as far as the ambulance stock, fine, that's every day. But I would be videotaping that, or I would, as a better rule, inventory is never done as one person. Never done it. And this was probably allowed as one person. It never should have gotten this far. If you stop the crime before it happens, so proper controls. But my two things, video, and nobody ever does either an ambulance or rescue inspection, right, of what we call the stock, or the sub stock in the inventory room. Never done alone, ever.
Good
How many
advice.
times we need this case, right?
Keep relearning it.
But now that we have 10,000 people watching a day, that would be everyone's going to know. Okay.
Well, I do want to thank the folks that have subscribed. It really appreciate it. We had a big bump up in the last week, and certainly if you're listening and you haven't subscribed, please do. It's going to mean the difference between us being able to continue doing this and not. So please subscribe.
And we love doing this for everybody watching, but there's so much good stuff that we. Every year after year, when hopefully we'll keep doing this every Monday, but every year you're going to look back and like, how did this happen again?
Yeah.
Okay. On the Curt Verone comment of you can't make this stuff up, voyeuristic. So a fight, and now I'm going to butcher these facts, but I'm going to make them very short, which is basically a woman gets a phone call who is or a firefighter.
Brad, you know what this is like? This is like you can't make this stuff up of the you can't make this stuff up. Because the voyeurism in and of itself is a you can't make this stuff up. But how this came to light is another you can't make this stuff up.
Yeah, and I didn't see the divorce action of this. I'm assuming there might have been one after.
Oh, yeah. No, it's in there. It's in there.
If I got it right, and I'm going to try to do this in 2 lines, but tell me if I got it wrong. The wife of the voyeur, right, notifies the victim that the victim had been many years earlier being video and audio recorded. I'm curious what's on the audio, but being video and audio recorded while at the firehouse. it was, they say he was fire chief. I don't know if he was the fire chief at the time.
I think he might have been the chief of a different department.
That's what it looked like.
There were several departments named, and but I believe he was the chief of a different department. I think he was a paid employee of this particular department where it happened. He was actually the IT person as well, as I understand it.
So that's what's going to kill him, not being the fire chief. So that was going to be my point. So here they, and we had a similar discussion last week or the week before, which I'll reflect on, but he records her in the bunk room, bedroom, whatever, and both video and audio. Now, just start with, on the audio side, in many states, I hate saying all states, but the recording of another person without you being party to that conversation, at least in New York State and many others, is a felony.
Right.
Without consent.
Right. Without consent, right?
It's what you call wiretapping, right?
It's under the wire. It's actually, when you record somebody's voice, it's eavesdropping. When you record it over the phone or internet or whatever, it's wiretapping. But most states, including the federal government, most states have them incorporated into the same criminal law. So whether you call it wiretapping or eavesdropping, it's usually a felony. It's definitely a crime.
New York State had a town supervisor in one of our local towns of Geddes get convicted of a felony for turning on audio recording his secretary. I mean, they're serious about this. You don't do it. In any event, so that's the facts, right? So briefly, and it was the wife of or ex-wife, I don't know, of the recorder, the person doing the recording, the voyeur, who notifies the victim that she found this, and I presume it was probably as some divorce proceedings. But here's the interesting thing. So this whole case is about scope of duty, right? And let me reflect to something I said last week, where I was working for the court at a time, but a state park ranger had raped a woman while the park ranger was on duty. They sued the state, and the state won. My judge dismissed the case because they said there was no duty of the state because the park ranger's duty did not include raping people during his shift. So even though he was on shift, he acted outside of his duty, and that's a normal, very useful and successful defense for a municipality to say he may have done it, but he wasn't acting in the scope of his duty when doing it. And that's
let me give you what I think is it's the same case, but it's a firefighter case, and happened in Sacramento, California, and the case I lecture on, the porn star costume ball case, where firefighters, you can't make this stuff up. Firefighters took apparatus to a local hotel that was hosting an event called the Porn Star Costume Ball. And the firefighters went inside. They met up with some off-duty firefighters, and I think it was one on-duty, one off-duty firefighter escorted one of the women out of the event, and they had sex with her on the truck. And they took, out to the parking lot, and they had sex on the truck. And
then made a movie called Backdraft.
Well, I don't know if Backdraft caused this kind of stuff. We never had this problem. As a young firefighter back in the 70s and 80s, we never had this problem. Then that movie Backdraft came out and wrecked everything for us. But at any rate, the victim sued. The victim reported it as a rape, but there was apparently an off-duty police officer that witnessed what happened, and based on his testimony, it did not appear to have been. He said it did not appear to be anything but consensual. So the prosecutor opted not to go criminal on the rape. She got an attorney. They sued the firefighters and the city of Sacramento. And the city's allegation, or city's defense, was that this was outside the scope of employment. And the woman's attorney also added another allegation besides scope of employment, said that negligent hiring and negligent supervision. And the court dismissed the entire thing, and they said it was outside the scope of employment. Therefore, there was no respondeat superior. There was no liability there because it was outside the scope of employment. And you can't backdoor yourself into a respondeat superior by claiming negligent hiring and negligent supervision. So it's a really interesting case called MP versus City of Sacramento et al. So if anybody's looking for it, they didn't disclose the identity of the victim, but it was MP was her, pseudonym for it. So, but at any rate, I think that's same principle there, but in a firefighter context.
And so the twist here, which is going to be so interesting, is this guy, as you just said, was allegedly in charge of IT. So the scope of duty question is so unique.
Oh, I didn't think of that.
Oh, that's where I thought you were going.
Oh, no, not at all. Not at all. That's wow. I hadn't thought about that.
So it actually is his duty to set up and monitor. So that's when I'm thinking of this. That's why I'm like, scope of duty.
Oh, wow.
Who knows?
You got a devious mind there, Councilor Pinsky.
Yeah, let me tell you. Okay, anyway, so how do we do? We good with that one?
Yeah. I just, we'll be doing our best to follow that one, and we'll see how it goes. So
let's talk ketamine and ego. This is, look, we know two things. All cops really want to be firefighters. Fact, it's proven 100%. You can't deny it. All cops want to be firefighters. But the worst problem we have is when firefighters want to be cops. And here, firefighters in this suit had the opportunity to act as police. And I'm just suggesting, if that's your mental attitude, that you are going to support and protect and act as the police while in your role as a firefighter, you better change your attitude. So this is how I take this issue. So the short of this is that there is an individual who ultimately dies, who blows a tire, pulls over into a parking lot. The police pull behind him, believe he's impaired, I believe. And the guy says, listen, just call your supervisor. I'm not impaired. I want to say something. In any event, supervisor shows up. The guy refuses to be handcuffed. I don't know what really transpired in the middle. Refuses to be handcuffed, ultimately is taken down and ankle cuffed and handcuffed, and still being unruly, such that, now let's get to the important point, the alleged paramedic gets here and allegedly administers ketamine with the with the alleged intent to sedate or calm the individual, which is probably not what the protocols in that EMS region say. And they use ketamine in such a way that it puts him into cardiac arrest, respiratory, then cardiac arrest. And he ultimately dies, even though he was momentarily, I think, revived. But I look at this as the paramedic saying, oh, I can do something, or I was asked to do something, I don't know, and I'm going to come in and violate, which is the point here, violate your Fourth Amendment and other rights to be free from search and seizure. And here is just a bad example of good facts for the plaintiff, and they're going to have to show there was a medical reason for ketamine. And since this guy was not having a medical episode beforehand, I have a real hard time believing. And what happened here is the court allows this to go forward. On my cursory review, this has got to settle. They're right. I mean, if the facts are as they allege,
and that's the thing. We don't we go based on what's in the complaint. Sometimes what's in the news media, but certainly some of the comments here. In fact, the medic, according to the complaint anyway, the medic said we have something that's going to allow you to have a good time, and then there was some comments there. Now, we don't know if a lot of this was captured on body cams. I know a lot of police officers back years ago were against body cams. I think today they're coming around. They understand that the importance of having body cams to protect them from false allegations. But so we don't know all of the details, but the man died, so we don't have his version of what happened. This is his family's version, and also the version that his attorneys are putting forward, and we don't know what that's going to be based on, bystander testimony or whatever. But boy, we've got to be very careful. And when it comes to ketamine, we've got to make sure that if we're going to administer it, we're not administering it to allow the police to take somebody into custody, because then that raises a Fourth Amendment issue. You're helping the police seize someone or arrest them. There has to be a medical reason for the administration of ketamine. And
And
again,
this is
maybe
an attitude problem.
maybe there was. Right.
Hard to imagine since he wasn't having enough.
Well, that's the allegation.
But
we don't know. I mean, if you read the complaint, or at least the facts as alleged, he was just driving down the road, no problem, and he had a blowout. And then the police actually came to, said, "Oh, we'll help you fix your tire," and then all of a sudden decided they were going to arrest him. I don't know how you go from A to B to C here. That it's the math doesn't add up. But
and here it's interesting. So here you have constitutional violations, right? Which are, and you may have the state law violations like negligent hiring again. So let's tie a couple things, because if I'm a viewer, I'm saying, well, wait a minute. It wasn't his duty to administer ketamine in that fashion.
Right.
And the truth is, and it wasn't his duty to help out the police. But here's the case. One, the constitutional violations escape any question of duty, right? That's the benefit to the plaintiff, is duty is only part of the negligence lawsuit, not part of a constitutional violation. So I want to make clear that for all the viewers. But, also, okay, so as to the negligence aspect, could they say, well, he was acting outside of the scope of his duty? And here, I don't think they could. Here, his duty of being a paramedic and administering care is so tied together. It might have been malpractice, but that's another interesting part about this, because he said this doesn't allege malpractice. And I want to talk about that because I have a good background of that. So the court says, we agree that this wasn't malpractice. And the reason it's not malpractice is malpractice in most states and federally is defined as diagnosing and treating, right? So a physician can diagnose and treat a condition. EMTs and paramedics do not diagnose. They interpret pursuant to a protocol, but they do not diagnose. They might treat, right? But they don't diagnose. So their care, usually this comes up into confidentiality issues, physician-patient privilege and all that. But since paramedics don't diagnose and treat, or diagnose, generally they can't be held liable for malpractice. And in this case, that was one of the statutory basis they were trying to go after him, to say, well, you can't sue us because it falls under the Malpractice and Tort Claims Act. And he said, it's not malpractice. And I didn't read that part of the decision, but I could pretty much write it. It's because you don't diagnose as a paramedic. And that would be the correct holding in line with many states.
Yeah, so if you're not under that medical malpractice statute, South Carolina has a medical malpractice statute that requires you to jump through a couple of hoops if you're going to allege medical malpractice. And if you don't, the case can be dismissed. That is what the defense alleged. And the court said, no, this isn't medical malpractice. This is more, basically common law negligence. And they're allowing the case to proceed along those lines.
And frankly, I'd call it straight assault. It's not even negligence. It was intent. And, it's intentional conduct, which could be important, except the date's probably, right? This just happened, didn't it?
No, not 2019, I think.
Oh, so I don't know when the lawsuit was, but, an intentional.
Yeah, 2019. The incident was 2019.
Yeah, and I don't remember when was the lawsuit. It had to be around that. But, normally an assault is 1 year. I would say this isn't negligence. They intended to administer the ketamine. They may not have intended to kill him, but they intended to do the action. So it should be a 1-year statute. I know we're way off, but this is how attorneys think.
Mm-hmm.
So, okay. So I don't know what it is about this week's cases, but.
Oh, it's every week. It's every week. Come on. Every week. It's just like, we don't have to have any creativity. It writes itself.
So look, I only know this because this happened at my firehouse as well, publicly knowledge. But here in California, a firefighter pled to child porn charges. That doesn't matter, right? If it was a plumber, they wouldn't have said a plumber did it. Of course, it's firefighter. But here's why it's additionally important, right? Is the way they found him was he hooked by his phone or his computer to the IP address of his fire department, and the FBI, I think, linked the IP address, found that he was the only one who linked to it that day and on successive days, and they found it was him. This is not uncommon. And I'm just going to say, I won't go too much in detail, but it's public record. This happened in my own firehouse many, many years ago, and they will find you. But You talked about something else. Well, when you're using your own phone, when you're using your own computer, that is not your own phone and computer once you hit the fire department's network. Now, I hope the fire department has a good privacy policy that says anything happening on our network is our domain that we can know. That's one of my standard HR policies, and something we should talk about in an HR conference with all of us. But nonetheless, it's, you better know. Now, this is just stupidity. Why you're looking at child porn ever, anywhere, federal crime, just don't do it. Why are you doing it at work? How bored are you? Go sharpen a Pelican or an axe or something. But Jesus, I mean, you really have nothing to do. Nonetheless, that's the whole story, and you just cannot make this stuff up.
Yeah, that's there's a case I think it was out of West Virginia that I use in my Garrity class, because there's the same fact pattern where a guy, and this is even a little bit worse, the case in West Virginia, but this guy apparently went out over the fire department's internet connection. I don't know if it's the union, like some places the union pays for the internet, some the city pays for it, however. But in the case in West Virginia, it is even stranger, because the firefighter went out over his officers' MiFi, like their Wi-Fi hotspot. Yeah, I know it, right? So now the FBI comes and they want to talk to the captain. They go, Cap, we got a question for you. And is this your hotspot? Yep. Well, what kind of stuff have you been doing on? Oh, I don't know, normal stuff. Well, how about going to this particular, not me, says, well, is this your email address? He goes, no, it's not. But, do you know whose it is?
It's the guy
As a matter of fact, I do.
It's our soon to be former
employee. And when you're done questioning this guy, I got some questions for him myself. Okay. But now the question became, did it trigger Garrity? Because did the captain order the firefighter to answer the FBI's questions? Did it, was he compelled to answer the questions by his captain and all that? So interesting decision. And the answer, the court said, no, he wasn't compelled, but it's one of those gray areas. That's why, we've got to increase firefighters' knowledge of the Garrity rule and when firefighters have a right to remain silent, when they don't, and how you can all of a sudden find yourself in the middle of this, incident involving local police, the FBI, and a lot of other people. And it doesn't help to say, oh, I didn't know. How was I supposed to know? So. Well,
we can't stop stupid people from being stupid.
No. But we can help smart people get smarter.
Yeah. But look, you put in good practices, you put in good policies, and then you do your best. I mean, that really is it. But some of these cases could have been, prevented by good policies. Some are just bad people going to do whatever they're going to do.
Well, let's just real quickly, let me just run down some of the cases that we really didn't have time to get through. A big decision is a case I've been following out of Lansing. I went out to Lansing about a year and a half, 2 years ago, and they had some problems. They're continuing to have some problems, but federal judge dismissed some of the claims of an African-American firefighter who's alleging racism. The case is going to continue on some of the other claims. There's a reverse discrimination case out of LA City filed by a white firefighter. And as part of that, the firefighter suing the city, but as part of that, he's subpoenaed and tried to get access to certain documents in the possession of a Black firefighter group. And so there's been some rulings that the firefighters, the African-American firefighters, are going to have to produce some documents in relation to that. We've got Billy's, case and a link going out in that. There was a couple of incidents there that are, we're not going to get into the details of, but, deputy chief resigns and, some other, another child molestation charge against the firefighters. So. But how about any last words here from Bill? You got anything?
No, I'm impressed with Brad's pickup on that scope of employment.
I know it, huh? I know it.
I look through these and so
yeah.
Thank you for that.
I'm in such defense mode on behalf of my clients all the time that I guess I'm used to it.
No, good pickup.
And I'm going to be out with Brad this week. Later this week, I'll be heading out to Verona. Verona, New York.
Oneida County. Yeah.
All right.
And-
For Brad's conference, and can folks still register for that, or is that?
They could. We've hit 400 people, so I doubt anyone would get a room at the moment. Great attendance, especially for kind of post-COVID, during COVID.
You had over 300, 350 last time, right? Last year,
200 something plus we offered some online, but this year, to hit 400 was great, and a lot of new departments. We're going to push them to start watching this. This weekly education can prevent so many problems for just this, 40-minute. We once said it was going to be 20, but we lied.
We tried. Neither one of us can shut up long enough to,
No, well, we get paid by the minute, but no, so we're super look forward to having you there. And one of your lectures is, you might as well be this, is how to end your career.
My biggest problem, I'm doing the class on how to end your career, how, really how not to, but how to firefight is the best way to end your career. And my biggest challenge is, narrowing it down to how many cases can I cover in an hour and a half, because, and this is just like over the last 6 months, never mind going back in time. So
I feel like we're going to write a song. Instead of 50 ways to leave your lover, it's going to be like 50 ways to, lose your job.
All right.
Look forward to next week.
All right, folks. And that'll do